Well, the latest that we're getting in: illegal, unfair and arbitrary. With those three words, the Supreme Court today dealt another devastating blow to the previous UPA government, terming the allocation of all coal blocks since 1993 illegal and arbitrary. Now, in one fell swoop, the Apex Court has confirmed that Vinod Rai's CAG had exposed in his report that Colgate scam was a colossal fraud spanning 18 years. A scam perpetrated by successive governments. The sharp ruling handed down by a special bench headed by Chief Justice of India R.M. Lodha. Now it places the immediate onus on former Prime Minister Manmohan Singh as well. Listen in. Fully under a cloud now are the 155 coal blocks allocated to private companies under Manmohan Singh's watch between 2004 and 2011, as well as 39 allocations made in the decade before he became Prime Minister. The total national loss, as the National Auditor assessed, is a staggering 1.64 lakh crore rupees. The court ruling is also a thumping vindication for former Comptroller and Auditor General Vinod Rai, who dropped a bomb last week, saying he was pressured to drop certain names from the report on the coal scam. Ironically, for the UPA, the shattering pronouncement by the Supreme Court today was in response to a petition based on his very report. The ruling is also the second biggest affirmation from the country's highest court of his fraud-watching ability after the 2G scam. But will the Supreme Court cancel the coal block allocations as it did with 2G licenses? Well, that will be known in exactly a week's time. All right, let's listen in. We're getting in reactions on this ruling by the Supreme Court.
सुप्रीम कोर्ट ने आज एक बहुत ही ऐतिहासिक और महत्वपूर्ण फैसले में कोयले के जो ब्लॉक्स के जो एलोकेशन करे गए थे सन 93 से लेकर 2004 तक और फिर 2004 से लेकर 2009 तक सबको अवैध डिक्लेयर कर दिया। और इस वजह से सारे एलोकेशंस जो केंद्र सरकार ने किए थे, चाहे पब्लिक सेक्टर यूनिट्स के लिए चाहे निजी कंपनियों के लिए, सबको अवैध डिक्लेयर कर दिया है।
I'd like to cut across at this point of time. My colleague Jaskirat Singh Bawa has been reporting from the Supreme Court on this landmark judgment. He's joining us live at this point of time. Jaskirat, the question I want to ask you is, of course, this is a landmark judgment which has been given by the Supreme Court, but will the licenses of these coal companies be and these coal allocations be cancelled?
Well, that is a subject to further hearing, as has been specified by the Chief Justice of India today, and that further hearing will commence on the 1st of September. For now, on a principal basis, they've all been held illegal. All coal block allocations have been held illegal. The Supreme Court went so far as to say that the manner in which the allocations were done was arbitrary, and there was no transparency, and that it was done on a very ad hoc basis. So obviously, there's a very harsh indictment coming down very hard on the manner in which this entire allocation has taken place, not just by one government, but across the board for at least the last 2 decades.
Successive governments since 1993.
But as far as the cancellation...
Yes, Jaskirat,
since 1993.
You know, Jaskirat, the question I want to ask you now is, somewhere down the line, it also completely reaffirms with what Mr. Vinod Rai had been stating.
Well, that's correct, absolutely. So this is pretty much, though we are still waiting for the proper written order of the judgment to figure out what the Supreme Court feels was the correct notional figure or the correct figure as far as the loss is concerned. But yes, in principle, they seem to have agreed that the manner in which the allocation was done was totally incorrect, that there could have been a more transparent way that the allocations could have taken place, that there was a lot of ad hocism that had happened. However, a big question coming up now is, because going forward, just the fact that they've been held illegal, is that sufficient? Because the big question right now is, will they be cancelled subsequent to now? They will be taken on case-by-case basis. The Supreme Court is even mulling on the option of perhaps roping in some retired Supreme Court judges to form a small committee to look into this on a case-by-case basis.
You know, but Jaskirat, you've been covering both. You covered the 2G case and you've covered the this case very closely. So the question I ask you is there precedence? If you look at how the 2G case in allocations were cancelled, could that happen in this case as well?
Well, with the 2J case, it was an all-out cancellation right then and there. All 122 licenses were cancelled. Of course, there were some repercussions of that. Perhaps it's only a speculation right now, but perhaps the Supreme Court understands that there are economic repercussions on the subsidiary and tertiary industries, on people and their employment, thousands of crores of even legitimate investments that may have been brought into question over here. Perhaps for that reason, they have not gone ahead and cancelled. Just as a broad example over here, often you see that colonies are held illegal but later on regularized.
Yes.
So it's not a very hard and fast black and white rule that anything that is held illegal is cancelled right on the face of it. Of course, Supreme Court might as well actually go ahead and cancel all those licenses, but that is a matter of wait and watch.
All right, and we're going to be looking at that very closely. My colleague Jaskirath has been tracking this case, and he'll keep getting us the very latest on whatever the news break on that is.